which would revert back to the original person involved in the trade of human beings. What they're basically done in this is if you held a child by the hand, a 14-year-old by the hand, and walked her from the living room to the kitchen of the house and had sex with her, by the definition that they're trying to use, that would be the trafficking or the movement of an individual from one place to the other. And that is not what is imagined by the passage of that bill. Now, the clear reason why they did it, Judge, is because by doing so, the trafficking statute is a super first-degree felony with punishment range 25 years to life with no possibility of parole, up to a 35-year cap. So what they have done, and is no different than the seizure of evidence, the illegal seizure of evidence in this property. Everybody's trying to cut corners and take short stops or shortcuts to trying to get what everybody wants to see the result of a particular case being. And as I said, the Ritz case, to my knowledge, was the first that I could find where that had ever been looked at or discussed by the Court of Criminal Appeals. And I certainly believe this isn't going to be the end of the discussion regarding the constitutionality of this statute. So, Your Honor, at this time, what I would do is I would like to, if the court will allow, I would like to offer all of the arguments made, which the dissenting justices agreed to in the Ritz case.
Do I have the dissent here?
Yes, Your Honor.
Starts on page 5.
It'll start on page 5. It's the Court of Criminal Appeals case, and that one's first at 553. I believe this one is package 3. If not, I can give you another copy.
I'm sorry. Okay, I've got a couple of writs.
553, 302, page 5.
Page 5. And this is the continuous trafficking statute.
Yes, sir. And the arguments produced are the same arguments. I think the same arguments that I've been with. We met 2 months ago with the district attorney's office of the appellate. I came forth with these arguments at that point in time, and their position is we think we can do it. We're going to go forward. The fact that they think that it's legal, any one person believes that something is legal doesn't make it so, Your Honor. And it's beyond me how the Court of Criminal Appeals on this first look, which was correctly decided by the dissenting justices. If the initial question is the legislative intent, to ignore it to the degree that the majority did in this decision is, I believe will not withstand further appellate scrutiny.
This was delivered on the 2017. Has it been taken up since then at all?
No, Your Honor, the Court of Criminal Appeals has not heard another case on this yet.
Okay, so this is pretty much it. Is that what you're telling me?
I have a lower court case that I already provided to the defense counsel, and I'm going to bring up, but it has not yet reached the Court of Criminal Appeals.
Okay, so really this is basically our standing right now. Okay.
Yes,
All right.
And, Your Honor, no matter what I appreciate that, no matter what our standing is, this case, I believe this issue will go beyond the Court of Criminal Appeals for purposes of appellate review. And I want to make sure that for all of those reasons, for those purposes, that all the arguments adopted by the dissenters in the Ritz opinion will be adopted and carried forward as the arguments of the defense in this case.
And that is granted. So we'll adopt.
And, Your Honor, Your Honor, I also wanted to challenge and contest the Your Honor, I also wanted to object as unconstitutional the provisions in 2802 and 2803, which set out that it is permissible for jurors in a continuous, when deciding whether or not a person is guilty of a continuous offense, be it continuous sexual assault or continuous trafficking, that it is not incumbent upon the jury to be unanimous in regards to the specific acts that the defendant has committed to be found guilty.
So what do they have to do? Just be unanimous in
If they, if the
in one of them?
They don't have to be unanimous as any of them. That's my objection. The 2802, 2803 allows them where multiple matters and means are pled by way of alternate counts. You could have 3 jurors think one count was proven, 4 another, and if any of them agree that, if they all agree that at least one of them was proved, then that's sufficient. And I believe that's unconstitutional. It's an impermissible allowance of the state to gather and garner a conviction based on insufficient evidence.
Your Honor, the state was not providing notice on the defendant's challenge to the constitutionality regarding the means under the continuous statute of the juror being able to find an individual guilty. You know, there's multiple paragraphs of prohibited conduct.
No, I don't, and I'm certainly not trying to throw anything out here. Certainly, we have no problems giving the state ample time to review, look at, and argue whatever they want in response. But constitutional arguments, I think, my understanding is correct, constitutional arguments can be made at any time in the proceeding up to the proceeding. I mean, if you're going to state it, they have to be stated at the proper time. I believe pretrial is the proper time. I also have a objection.
I'm assuming that's never been taken up either since we have
That's
this
correct, Your Honor.
long
This
case.
is the first time here in court that the state has heard this objection by defense counsel regarding the more than just the continuous human trafficking charge and getting into jury deliberations and how they do each unanimous decision on finding someone guilty or not.
I'm assuming there's, I haven't looked, but all the rest of these are just, is there a continuous
There is
alleged
no,
here? No?
No, there is
Is
not.
there a continuous what?
Sexual assault alleged in either of these are
No,
just,
continuous traffic.
okay, I'm just asking if any of these other cases do that. So this is sexual assault of a child, some online solicitation, things of that nature. And then this statute here, the continuous trafficking statute. Okay, all right. Sorry, so, go ahead, Mr. Johnson.
And so Judge, that is my argument as to the allowance by the statute regarding the state's attempt to seek conviction under the statute, that there is no requirement that the jury be unanimous in the findings as to any of the particular alternative manner and means that are pled in the indictment. And so I believe it's a violation of the due process rights of the defendant to allow him to be convicted under such a vague and ambiguous standard. And we would object to that, recognizing equal protection under the laws of those who are charged with other criminal offense, which there is a requirement of unanimity by the jury as to the manner and means alleged. So the fact that the state has now come before the court, and again, this is all under the backdrop, Your Honor, of the state seeking a charging instrument to inflict the greatest opportunity for the most punishment that can be assessed, and also to seek a way to subject him to the lack of applicability of the parole laws, which I'm about to object to in just a moment. But you have to understand that all of these arguments are wrapped up in the entirety, and they can clearly be seen with what I stated to the court earlier, that a continuous mechanization of this process designed to try to inflict the most harm upon a person who the legislator of our state has gone through history, and before enacting the continuous trafficking statute, Your Honor, or the continuous sexual assault statute, the defendant was not subject to anything more than the prescribed penalties for the conduct that he committed. And this ability or this attempt to now bootstrap it into something which clearly the legislative history shows is not even the purpose or intent of the whole statute for, is nothing more than the state's desire to seek punishment not prescribed by the law or not allowed by the law. As I said earlier, the statute 2803 by law carries a minimum punishment of 25 years to life in the penitentiary with no possibility for parole to be considered, no good time credit to be awarded, which every other offense that the state alleged against him through investigation, through indictment process, through the entirety of the process, he would have always been allowed to have had a consideration given for parole, a consideration given for good time. So he's being subjected to this, and it's violative of his due process and his equal protection rights, because what he had, it's not fair, it's not constitutional, it's violation of his rights to subject him to punishment that others in the same situation are not subjected to. And again, it's the constitutionality of the whole process here that I'm objecting to. I also object to 508.145A of the Texas Government Code. And the Texas Government Code provides the laws in regards to the applicability of parole to individuals convicted of various offenses. It's the one that sets out that the defendant on a conviction under a statute of 2803, section 7 or section 8 is not eligible for it to be considered for parole. That's a separate section of the Texas Government Code. I'm objecting to that. That denies the defendant equal protection and due process of law, in that he is being singled out based upon the state's attempt to use the statute incorrectly and unconstitutionally against him. He's being singled out for and having his parole eligibility and his parole considerations taken away from him to the exclusion of others in the same situation as he is, Your Honor, based upon a punitive desire by the state to bootstrap this defendant's conduct into a statute that it was not designed to prescribe. So the entirety of my objections, Your Honor, are the 2803 being used in its entirety as in the dissenting opinion, the constitutionality of 2803 and any statute that allows the defendant to be convicted on less than unanimity by the jury, and the unconstitutionality of the statute and the denial of equal protection and due process that it gives the defendant by taking away his rights to be considered for parole. And that's all we have.
Thank you, Mr. Johnson. Responder, are you addressing this? I'll give you some time on the unanimous manner and means. If you'd like that, that's fine.
Yeah.
But I believe Mr. Johnson's right, it can be raised at.
I apologize for I apologize for not saying something earlier. I mean, we'd like to resume this in a week or so, or I'll be, I don't know if that can give me plenty of time to do that.
Well, take a look at it and I'll give you some time, but obviously the rest of the motion I'd like to be addressed.
Yeah, sure. And also, this is the first we've heard of this parole and his objections to section 508 of the Texas Government Code. If you could give us some time to get to respond to that as well.
That's fine.
Thank you. Your Honor, simply for simplicity's sake, I'm also providing copies of the statutes that we're talking about. Simply so that you have them.
When was this statute originally codified? Is that the 2011 date where they changed?
Which statute, the continuous or the trafficking?
The continuous trafficking.
The continuous, Your Honor, it looks like it was first codified in 2011.
And where? Okay, 2011.
And Your Honor, I'm actually going to respond mostly by reference to Griffin versus State, which I provided to the court and to dispense as well. This is another case very similar to what happened in Lawrence. And Griffin, just so you have the procedural history of Rich, Your Honor, Rich was originally decided by the Court of Appeals of Texas out of Austin, and they applied for a petition for which the Court of Appeals decided was improvidently granted. Judge Newell filed a concurring opinion in which Herbie, Geary, and Keel joined, and then the dissent, which Janet keeps on responding to, was filed by Judge Keller and joined by Judge Walker. So ultimately, there was no actual majority opinion out of this other than the finding that the granting review was a product, which is really, and then we can discuss the currency descent from there. Griffin, like this case, it's a situation in which, or somewhat like this case, this is another defendant meets underage girl, starts picking up and driving her at different locations to have sex. There was a motion for directed verdict and a challenge to the sufficiency of the evidence, and the court looks at those two things together. In particular, the court did look at the definition of traffic, which was provided in the statute, and that's 2801. I think I've been wearing my copies. 2801, which traffic means to transport, entice, recruit, harbor, provide, or otherwise obtain a person by any means. The defendant in that particular case is arguing similar to here, because that the evidence didn't show that there was trafficking because she wasn't forced into slavery or prostitution, and that she was abused in ways familiar to the ordinary prosecutions for sexual abuse of children. And he argued, much like what the dissent argues and writes about, the fact that the statute requires two individuals, a trafficker and a beneficiary, and that's based off of the language of the code. If you look at 2002A1, 3, and 5, it's written as though it's taught, there's the criminalized conduct is the trafficking of another person. So that would be the trafficker. And then A2, 6, 4, and 6 are written as though for a beneficiary. So they're arguing that there's a trafficker and a beneficiary, which is similar to this. That's requiring two people involved. So he could only be guilty if he took the girl to a beneficiary who was not himself. However, we're going to look at the statutory construction, which is done de novo. And constructing a statute, courts give effect to the plain meaning of its language unless the statute is ambiguous, or the plain meaning would lead to absurd results that the legislature could not have intended. At that point, you can look at extra textual sources such as legislative history. In ascertaining the plain meaning of a word, review words and phrases in context to ensure that according to the rules of grammar and usage, and you apply the rules of grammar, etc. So looking at writs, then they looked at writs versus state, which is their major argument. In that particular case, the defendant picked up a 14-year-old girl on multiple occasions, drove her to different locations to have sex. And they said, oh, this isn't what's continued traditionally in human trafficking. But that being said, they then said the unambiguous language of the statute is broad and included the act of driving the victim to Ritz's home in order to have sex. And they disagreed that it led to an absurd result. So they're saying the language is unambiguous and that the language does not lead to an absurd result. This court explained it's possible that the legislature wished to significantly increase the sentences available for persons who commit sexual crimes involving children by including all such crimes under the trafficking umbrella, or intended to classify that type of behavior as trafficking because it determined that removing a child from the safety of his or her own home, driving her miles away to the seclusion of the defendant's home in order to sexually assault her is particularly egregious conduct. So they're saying the legislature could have had this intention from the reading of the statute. The Court of Criminal Appeals then received this case, they dismissed it as improperly granted, and you have Keller's dissent, which the defendant argued. However, in response, there is Newell's concurrence. Newell's concurrence, first off, says there's no room for material improvement on the Court of Appeals opinion, period. He says, this is exactly what I would have said, the Court of Appeals opinion. And he continued to say, if the legislature truly envisioned two culpable actors within the same offense when drafting the statute, it would have said so. And that the legislature did not specify that the person engaging in human trafficking in Section 7 had to be different from the person who was victimizing the child. The concurrence and reasons the legislature contemplated criminalizing situations where the trafficker engages in both the traffic and the victimization. In addition to situations where the trafficker transports the child without subsequently victimizing her, and focused on protecting exploited children, not exempting human traffickers from criminal liability for abusing those whom they traffic. And the concurrence concluded that the governing statute is not ambiguous. So you have four judges, I believe it was Yeary, Newell, who said, no, the statute is not ambiguous. So then you never even get to the legislative history portion of it, because if it's not ambiguous, you don't need to. You're looking at the language of the statute. And the suggestion that it is ambiguous does not spring from the text of the statute itself. It comes from reading terms into the statute in order to justify a conclusion that the statute is ambiguous. The concurrence determined that the construction adopted by the court would not lead to absurd results, because it was at least possible that our legislature did intend to classify Ritz's conduct as trafficking based upon the plain text of the statute. Therefore, it's unnecessary to look at any extra-textual factors to resolve this issue. So essentially, you have Newell's concurrence basically saying, we totally agree with the Court of Appeals opinion. The language of the statute has a clear meaning, it's unambiguous, and it doesn't lead to absurd results. Therefore, you don't even need to look at legislative history. And then the legislature could have intended that intent. Now, this decision, the one that came out in 2017, the legislature has met since then. They have not done anything to change the statute. They have seen how the courts are applying the statute and how it's being used, and the Texas legislature has not done anything to change this.
Excuse me, I'm going to object to any statement that the legislature has considered this issue and not acted. There's no evidence of that. There's no evidence of that in any of the opinions. There's no evidence that this has been recognized and ignored by the legislature.
Good.
So that's when applying the Ritz decision from the Court of Appeals and Ritz's concurrence from Judge Newell, Griffin then continued to say that we reject Griffin's assertions that an individual cannot be convicted under the trafficking statute if he engages in trafficking in the sexual assault of the victim, construing the statute and the circumstances present. And we don't believe that the application of the statute in these circumstances is something the legislature could not have possibly intended. So that particular, in this particular case, this is exactly, Newell's concurrence and Ritz is exactly on point. Griffin is exactly on point, looking at this and saying, absolutely, the legislature, the language is clear in its plain meaning, it's unambiguous, and it does not lead to absurd results. Therefore, this prosecution pending report is not unconstitutional, and his motion to quash should be denied.
May I respond briefly, Your Honor?
Yes, sir.
The arguments made by the state, Your Honor, the analysis was, I believe, somewhat correct, but the applicability of the argument to the law is a little misstated. One of the questions is, does the application of a law to determine whether or not it would be arguably unconstitutional, whether or not it would lead to absurd results? Okay, and so that goes back to the entirety of my argument regarding the constitutionality of the whole process that we've got here, all of the aspects of it, because everything that the defendant was accused of doing is prescribed by the penal code. He was indicted for such, he was being subjected to the penalties for such, and we were going along until the state starts trying to bootstrap this conduct into a provision, another provision of the law. So the first question for this court, and the appellate courts can sit there and say, well, we don't necessarily think it's absurd, but when it gets down to it, the question is not whether or not an appellate court thinks it's absurd, is whether or not in the practicality and the application of the statute to a particular individual leads to an absurd result based on the equal protection of this defendant, the due process of this defendant to be treated equally to others in his condition. He is now being subjected to a penalty range that he would not even be considered for parole until the expiration of the maximum penalty for everything that he had been accused of and alleged to have done. Every second degree he did. So is it absurd? Would it lead to an absurd result to allow the state to come in here and bootstrap his prosecution under this theory? Then, and as I agree with the state, if it appears that it could, then you look at the legislative history. The state sits there and argues it doesn't require two people for trafficking. The legislative history of the statute says it is designed to prescribe the trade of human individuals. And the trade of individuals, Your Honor, it requires, it mandates two people. You have to have one person trading something to another. And is this an absurd result? Yes, Judge, it's absolutely. The defendant is accused of crimes in this county, and he is before the court, subject to the penalties for what he's done. The state's trying to use this entire new theory to try to up the penalty against this defendant and make him different than others in his position. That's what makes it absurd. That's what makes it unconstitutional. That's what leads to an absurd and unjust result, Your Honor. And this court has the power and the ability to stop it. You have the ability to say, I've got the legislative history right here in front of me. Was he trading in human trafficking? I don't find that he was, because he clearly was not. And all of the legal semantics of going back and say, what's trafficking? Well, walking from your living room to the den, walking from or driving around to the corner store, to the local park. Anybody can sit there and say, well, that's traffic. But the purpose of the entire statute was to prevent the trading of human beings for forced labor or forced sexual servitude. And we don't have it. And is it going to be an absurd result if he's allowed to go to trial and receive a sentence that is so far out of whack to what everybody else in his similar situation would be? Yes, it would absolutely lead to that result. And that is the issues before the court. And we're going to ask the court to rule in favor of the defense on each of the issues that we've raised.
Thank you, Mr. Jones. Anything further from the state?
Yes, Your Honor, very briefly. First off, regarding the multiple charges, if you look at 2002A-C, the conduct constituting an offense under this section also constitutes an offense under another section of this code. The act may be prosecuted under either section or under both means, or both sections. So that's clearly part of the statute as drafted. And looking very briefly, looking at whether a particular result is absurd. Judge Moore said this is a dangerously subjective endeavor that should be reserved for truly exceptional cases and not the mere oddity of illegal absurdity. Your Honor, in this particular case, this is very clearly something the legislature could have contemplated and it's not absurd. So I just want to briefly jump up. Thank you.
Just if I could just respond briefly, so that we're clear. The statute that allows the individual or conduct would fit in the category of another statute allows the prosecution of the other statute is designed to allow someone accused of trafficking to be charged for a lesser offense. It's not a blanket allowance of the state to say that we're going to take conduct that doesn't fit into this statute and force it upwards. That's not what that statute's talking about. You have to go to the legislative history to see. And the legislative history, I'm not going to keep repeating myself.
Well, let me just go ahead and stop everybody. We're gonna take this up again. I'm gonna give the state an opportunity to look at those other issues, the parole issue, and then the whether or not the unanimous manner means make it the constitutionality of that particular issue too. So we might as well take up the whole, because we can't really address one without the other. So I'll give them some time to take a look at that. And obviously I'm not going to just let y'all submit or something without Mr. Johnson being able to respond. So we're just going to have to take it up again. All right. So I will take the suppression issue. That's a little more straightforward. Obviously, we've all dealt with those issues quite a bit. So I'll take a look at that, read the case law, and get back to you. And then we will recess on our pretrial. And we will continue the motion to quash and all of its elements at a later date where I can get y'all altogether. We're off the record.